So get this, Elon Musk is on a global manhunt, but he's not looking for a person. He's hunting for a secret, a piece of evidence he believes could totally upend the world of artificial intelligence. This isn't just another lawsuit, it's a corporate mystery that spans continents. Let's break it down.
And it all boils down to this one single question. Musk is convinced that the key to his entire case, a case against some of the biggest names in tech, is hidden halfway across the globe, locked away inside a company we're not even allowed to know the name of.
All right, let's set the stage. Back in August of 2025, Musk's company xAI filed this massive antitrust lawsuit. The targets? Apple and OpenAI. The accusation is a big one, that they're illegally working together to create a monopoly in the AI market. And what kicked this whole thing off? Well, the story goes it was when Musk's own AI chatbot, Grok, couldn't even crack the top of the App Store charts. Now look, in a case this big, you can't just show up with a hunch. You need a smoking gun. You need cold, hard proof of a conspiracy. But here's the twist. Musk's legal team isn't digging around in Silicon Valley. Nope, they're certain that the proof they need is in South Korea.
Right, so how in the world do you even get evidence from a company in another country for a US lawsuit? This is where the story takes a really fascinating legal turn.
And we're not just guessing here. This is all coming from official court filings. A U.S. federal judge has actually given xAI the green light to go after this evidence abroad. The order is signed, sealed, and on its way to South Korea.
But wait a second, how does that actually work? I mean, a U.S. court can't just order a Korean company around, right? There has to be a formal process for this, a system that makes it all legit.
Well, there is, and it's all thanks to this surprisingly old but incredibly powerful international agreement, the Hague Convention.
The whole process is overseen by this body, the Hague Conference on Private International Law. And this isn't some brand new treaty cooked up for the digital age. We're talking about a formal convention signed way back in 1970. It was literally designed to create a reliable legal channel for exactly this kind of situation.
So what's the big idea behind it? Simple. It's all about mutual judicial cooperation. Basically, it's a pact where all the member countries agree to help each other's courts get the facts they need to decide on civil cases. It's an international system of favors. Okay, so the process sounds simple enough, at least on paper. First, the US court writes up a formal letter of request. Then, that letter gets zapped over to a special office in South Korea called the Central Authority. And from there, they pass it to a local Korean court whose job is to actually go get the evidence.
All right, so we've got the how, but that brings us right back to the billion-dollar question. Who? Who is Musk's mystery target in South Korea?
Now, the actual court documents are sealed tight, but you know how it is. Industry watchers have their theories, and they've pretty much narrowed it down to three big names. You've got Samsung and SK Hynix, who both just signed these massive deals to build the hardware for OpenAI's next-gen Stargate project. Or it could be Kakao, the messaging app giant that plugged ChatGPT right into its service for its 50 million users. All three have very recent, very deep connections to OpenAI.
So, the US court gave the thumbs up. Awesome, right? Well, not so fast. This is where the story hits a major speed bump. Getting permission is one thing. Actually getting your hands on the documents is a whole different ballgame.
Getting that approval was just step one. Now Musk's warriors have to navigate this incredibly complex legal maze, and it's filled with traps.
If you want to know just how tough this is, just look at the numbers. Back in 2012, South Korea got 19 of these requests. You know how many they actually followed through on? 6. A whopping 13 of them. That's nearly 70% just went nowhere. The historical odds are frankly not great.
So why? What's the roadblock? A huge part of it comes down to something called an Article 23 declaration. See, South Korea and a lot of other countries have this rule. It basically lets them say no to the kind of broad, sweeping requests for documents that are super common in US lawsuits. To them, it looks like a legal fishing expedition, where you're just hoping to find something, anything, useful.
And it doesn't stop there. There are a bunch of other practical hurdles. If the request isn't translated into Korean, good luck getting it looked at quickly. You can't just ask about general topics. You have to submit a specific list of questions beforehand. And even then, a Korean judge can look at your questions, rephrase them, or just toss them out completely. The local court is in total control.
You know, when you peel back all the layers, you realize this isn't just about some legal squabble over an app. This is way bigger. This is a geopolitical chess match being played with technology, national policies, and straight-up global power. Which brings us to the final and maybe most important piece of the puzzle, the global tech chessboard.
What we're really witnessing here is this massive collision. On one hand, you have the slow, methodical world of international law, represented by that old Hague Convention. And on the other, you have the breakneck pace of global tech policy where every country's scrambling to control these new giants.
And you have to understand, all of this is going down at a really critical moment. A recent report is warning that South Korea is thinking about new digital regulations. And the warning is pretty clear. If they're not careful, their new rules could end up hurting their own homegrown tech giants and the big US players, creating a perfect opening for their rivals. And that, of course, brings us to the elephant in the room, the China factor. Chinese tech companies like Temu and TikTok are already exploding in popularity in South Korea. The fear among analysts is that if new regulations weaken the established American and Korean companies, it creates a vacuum. And you can bet Chinese firms are more than ready to step in and fill it.
So, at the end of the day, it's pretty wild to think about, isn't it? A multi-billion-dollar corporate war over the future of artificial intelligence might just hinge on the rules of a legal treaty from 1970. It's a powerful reminder that even in this high-tech world, old rules can have very, very sharp teeth. So the question we're left with is, could a dusty old treaty actually end up deciding the future of AI?
Thanks for watching. Don't forget to like, subscribe, and share. It really helps the channel grow. See you in the next video.